remember, Matter Mr. McLean, I don't know if you recall, but it would have been for a transaction with Tobago Land. And when I looked at the sale agreement, I noticed that the parties to the agreement would have been the proposed vendor with his name to the seller. However, when we did our searches, we realized that he had in fact owned the property as joint tenants with his wife and did not yet sever that joint tenancy or anything, right? Or did not, state that anywhere in the agreement. I think also in that matter, there was an incorrect referencing to the deed in the sale agreement. It referenced a parcel next door to it, very close, but next door. And in law, had we not observed those things, the entire agreement could have been void or voidable. Because imagine if, that vendor represented himself as being the owner, when in fact he was not the owner, he was a co-owner with someone else. The entire agreement would not have been binding. And if the purchasers gave that man their money without the signing or agreement of his wife, he would not, there's no agreement. So he could have easily come after and say, well, they gave me this money as a gift, I don't own nothing by myself, So it's little things like these is important to have trained legal eyes observe things for loopholes, for errors, for things not expressed, right? Things in a sale agreement that I have seen are errors are also sometimes somebody may be applying for letter of administration. They're still applying. And during that process, they put the property up for sale. And in the sale agreement, they represent themselves as being the LPR already, as if they got the grant, without saying that are waiting on the grant. That little misrepresentation of their legal capacity in the transaction can make the entire agreement voidable, right? Or other things like sometimes people have a will and they're relying on the will to sell a property. They don't have the deed. Now, these things may sound reasonable to a real estate agent. Like, I have the will here. I just didn't probate it yet. I want to exercise my power of sale as an executor. These things can be done, but not just so. There are certain things, there are certain wording, there are certain legal construction that need to be present in the sale agreement. We ain't reached the deal yet. We're talking about step one. The sale agreement before the sale the transaction process begin. Another one the idea that comes to mind, a young lady came and in her sale agreement, there was no clause about good and marketable title. They never allow her to say, well, in the event that there is any discrepancy, no money back. So if you realize that things went south, crap, will smoke your pipe, as we say in Trinidad and Tobago. However, the thing about that, and they would not have been wrong, because the ordinary legal, the ordinary doctrine that governs conveyancing transaction is caveat emptor, buyer beware. So it's actually the responsibility of the purchaser to do their own due diligence. And if you sign to an agreement and you sign where there's no provision for you to check for due diligence, and you sign away and say, I don't need that. If you find something after you have signed, there is no obligation for you to stop the sale and say there's a mortgage, there's a judgment, there's a lease. You don't own it. You don't have good title. They will say, well, there was never a clause that said you needed good and marketable title to be bound to this transaction. So something simple like that clause not being, and I'm telling you, the young lady showed me the agreement from a reputable mortgaging company, and they did not have that clause. So she didn't have an exit for the transaction. Even if she found bad title, There was no provision expressed, and why is that important? It means that she will have to fight them down in court and prove that it would have been an ordinary and reasonable expectation, even though the clause not there, what are industry standards, and she find that which is legal course, which is bringing a claim in litigation and all that jazz. Whereas you could prevent that by having the clause inserted in the sale agreement before signing the sale agreement, right? Which your real estate agent is not under any obligation to do for you, nor are they trained to construct sale agreements. Yeah? How do you feel about that, Mr. McLean?
Yeah, I totally agree with you. I totally agree with you, because we see some very scary things happening, in the industry. I could tell you one that I experienced personally some years ago, and it underscores the importance of getting a specialized conveyancing attorney with experience, right? Did all the right things, at least on my part, but the attorney wasn't experienced in conveyancing, right? I was fresh to the industry, and the attorney did a search. The name came back, showing up fair, fine. The deed, name, everything looks good. Vendor went ahead and made a significant cash payment. Significant, probably let's say half the price. Half the price. Yeah. Only to find out that there was another deed. Right? So apparently that deed was sketchy. Right? So these things happen.
Yeah, we live in Trinidad and Tobago. You remember you said that we live in a very intelligent country.
Yeah. People do some. It's crazy the things you see happening. It's just as scary as the news you see with the murders. It's realistic. Could be just as scary.
Yes, I like that point. You fake, and when you see people don't like RPO because you can't get away with murder. There's a lot of murder that happens in conveyancing law, like for one better term. And the truth is, especially with old law deeds or common law title, the chances are there. You mentioned conveyancing attorneys who are experienced. When you're green, come out. I remember being green back in 2012 or 10, and thinking, well, the title registered, that could never be fake, And here I am sitting in legal affairs, and I have a copy of the document. And even though in school you learn certain things, you have a very idealistic view of the society. Correct. And so your bubble bursts very quickly in conveyancing with that, and it's only a client to suffer. So when we are saying that we are discussing these pitfalls, because it catches even attorneys at law and administrative attorneys and conveyancers, right? Far less for a real estate agent who is trying to operate in this very dangerous space is landmines, literally landmines in land law, right?
Yeah. It's one of the things. Just good afternoon, everyone. Hi, good afternoon.
I see we matching, Mr. Paul.
Yeah, well, great minds. I was hearing you all, but I wasn't able to come on for some technical difficulties. But one of the cases that I think, and I don't know if it was mentioned, but I from what I've heard, we haven't mentioned it, was the last case, Ms. Daniel, where we had a situation of stamp duty and a structure not being completed and having different allocations of stamp duty towards it.
Right.
And I think in real estate is important. Sometimes you have a house that 60% complete, and they say, well, yeah, man, the steal of a deal, just do so and so, and you get through. But one of the things that is important to note is that a house that is not completed is considered land. and therefore the provisions in stamp duty that would be allocated or not allocated in this case, if you had a house, will not be done so with land. And so therefore you could find yourself in costs that you did not imagine that you would have to do because the house is not quote unquote complete. Now, what does complete mean? Complete has to be evaluated complete. It has to be in a position where you have your toilets in place, you have your kitchen in place, you have doors, you have windows. It must be an
Completion
envelope.
certificate.
Completion.
Correct.